Hello everyone, I'm Anuj Jaggi and I'm a legal intern with LEXIS and Company. And the topic for today's video presentation is Anatomy of the Administrative Action under Administrative Law. So an administrative action can be classified into generally four categories, which is rule-making action or quasi-legislative action. Next is rule decision action or quasi-judicial action. Third one is rule application action or administrative action, and the last one is ministerial action. So the executive performs variegated functions like to investigate, to prepare, and to adopt schemes, to issue and cancel licenses, which are the administrative functions, and to make rules, regulations, and bylaws, to fix prices, which are considered to be quasi-legislative, and further to adjudicate on disputes, to impose fine and penalty, etc., which are considered to be quasi-judicial. So the rule-making action or quasi-legislative action under this in the Indian Constitution, though this power is not expressly vested in the legislature, yet the combined effect of Articles 107 to 111 and 196 to 201 is that the law-making power can be exercised for the Union by Parliament and for the states by the respective state legislatures. It is the intention of the constitution makers that those bodies alone exercise this law-making power in which this power is vested. But in the 20th century today, these legislative bodies cannot give the quality and quantity of laws which are required for the efficient functioning of a modern intensive form of government. Therefore, the delegation of law-making power to administration is a compulsive necessity. When any kind of administrative authority exercises the law-making power delegated to it by the legislature, it is known as the rule-making power delegated to it by the legislature. It is known as the rule-making action of the administration or quasi-legislative action, and commonly known as the delegated legislation. Characteristics of legislation are generality, prospectivity, public interest, rights and obligations flow from it, and further, when an administrative authority exercises law-making power delegated to it by the legislature, it is known as the rule-making power. Further, the distinction between legislative and judicial function, it can be explained with a case law which was Prentice versus Atlantis Coastline, and it is a US case, and it was held that the judicial inquiry investigates, declares and enforces liability on present or past facts and under laws which are supposedly already in existence. Legislation on the other hand changes existing conditions by making a new rule to be applied thereafter to all or some part of those subjects to its power. The legislative function is general and relates to the future, while judicial function is specific, final and ordinarily relates to the past. Adjudication deals with what the law is, while rule-making deals with what the law will be in the future. Sometimes a single function may have all the three elements. It may be partly legislative, judicial and administrative. For example, the Interstate Commerce Commission fixing tariff of charges for any railroad is a legislative function. But a situation where there is a shipment of a mixture of coffee and chai. The decision to either change or a higher rate of a coffee or a lower rate of chai is more judicial in nature. It is legislative at the same time as it sets tariff for further such transactions, and the calculation of the total freight charges due to the particular shipment is an administrative act. So the further distinction between the legislative and administrative functions can be, there are generally two tests for this, which are the institutional test, where that which the legislature enacts is legislative, and that which the administration applies is administrative, and the second test is the applicability test, where an act of parliament is legislative function while an order of deputation is administrative. In the applicability test, there it puts an emphasis on extent and applicability of the act, and the legislative power is the power to make rules for subjects in general and for the prospective application, and administrative power exercised on the application of such withdrawal of such law to specific cases and particular situations. So I'll further talk about the topic in the next video, and I'll explain one or two case laws in that video too. Thank you.